Welcome to our call center manager and supervisor employment law training session. Today we will talk about the various employment laws that all managers and supervisors within our call center should be aware of and the expectations for protecting our company from violations. One of the most common areas that many companies have problems with relate to anti-discrimination and anti-harassment laws. The anti-discrimination and anti-harassment laws that pertain to our company include Title VII of the Civil Rights Act, the Age Discrimination in Employment Act, the Americans with Disabilities Act, and the Pregnancy Discrimination Act. These laws are enforced by the Equal Employment Opportunity Commission. What do these laws cover? Title VII of the Civil Rights Act prohibits employment discrimination against an applicant or employee based on race, color, religion, sex, or national origin, and applies to companies with 15 or more employees. The Age Discrimination in Employment Act prohibits employment discrimination against an applicant or employee based on age, meaning individuals over the age of 39. The law applies to businesses with 20 or more employees, so that would include our company. The Americans with Disabilities Act prohibits employment discrimination against qualified individuals with mental or physical disabilities. This law pertains to both applicants and employees and applies to companies with 15 or more employees, which would again include us. The definition of a disability may be quite broader than you think. The ADA describes a disability as a physical or mental impairment that substantially limits one or more major life activities, as well as bodily functions. The ADA, as amended, provides that major life activities include, but are not limited to, caring for oneself, performing manual tasks, seeing, hearing, eating, sleeping, walking, standing, lifting, bending, speaking, breathing, learning, reading, concentrating, thinking, communicating, and working. Major bodily functions include, but are not limited to, functions of the immune system, normal cell growth, digestive, bowel, bladder, neurological, brain, respiratory, circulatory, endocrine, and reproductive functions. As you can tell, the ADA's definition of a physical or mental impairment encompasses a lot of activities. That is why it is important that you understand that the term disability can have a very broad definition. Finally, the Pregnancy Discrimination Act prohibits employment discrimination based on pregnancy status, childbirth, or related medical conditions. These laws pertain to our job advertisements, recruitment and hiring practices, project assignments, disciplinary actions and terminations, and promotions to lead status. How can we prevent and avoid discrimination in our workplace? Managers and supervisors should treat all employees fairly and equally. Think before you speak or act. Consider the potential consequences of your words and actions. Do not base any employment-related decisions on race, color, religion, sex, national origin, age, disability, pregnancy status, or any other protected status. You should stay alert for anyone else's activities that could be perceived as discriminatory. By following the company's standard operating procedures, supervisors and managers can avoid potential discriminatory practices in your day-to-day activities. Job advertisements may be posted only with approval of the call center manager and/or corporate office staff and will be reviewed to ensure that the ad only contains information related to job description and the necessary skills required to perform the job. Project assignments must be based only on interviewer quality and productivity. Disciplinary actions and terminations must go through the proper channels of the call center manager and corporate office to ensure that the pre-established procedures are being followed in these matters. All terminations must receive prior approval by the Vice President of Human Resources. Promotions to lead status will be approved jointly by the call center manager and respective corporate office staff and be based solely on the individual's demonstrated understanding of interviewing procedures and skills in communicating these practices to other staff. How can we avoid and prevent discrimination in our hiring practices? Those involved with applicant interviews and hiring should be especially careful when making hiring decisions. There are some do's and don'ts to the hiring process. Do follow the prescribed set of applicant interview questions. Applicants may bring up information related to a protected class in their response to questions. Do address this information only in the manner in which it would affect their ability to meet the job qualifications and expectations. Do make hiring offers based only on the applicant's abilities to meet the typing and reading requirements and availability to work the designated shifts. Don't ask questions related to whether the applicant has or intends to have children, including current pregnancy status, or any questions about their race, national origin, religion, sexual preference, age, or disability. Don't ask questions about participation in any organizations that might identify the applicant as someone within those protected classes. These laws we've been discussing also cover harassment. Harassment is unwelcome conduct that is based on race, color, sex, religion, national origin, disability, and/or age. As you are aware, our policy manual details the company's stance on harassment of any kind. As supervisors and managers, you must be observant of potential harassment. Sexual harassment is one of the most talked about issues, especially in today's society. Sexual harassment may include making derogatory sexual or gender-based comments, jokes, or other offensive comments, sexual flirtations, advances, or propositions, making sexual gestures, displaying of sexually suggestive objects or pictures, possession or display of suggestive or obscene material, either printed or electronic in nature, making or threatening reprisals after a negative response to sexual advances. Other types of harassment based on a person's national origin, race, color, religion, age, gender, disability, sexual orientation or identity, appearance, marital or other protected status, may include verbal comments that are offensive or unwelcome regarding these characteristics, including slurs and negative stereotyping, nonverbal actions including distribution, display, or discussion of any written or graphic material that ridicules, denigrates, insults, belittles, or shows hostility, aversion, or disrespect toward another individual or group. How should you address a potential discrimination or harassment situation? What are your responsibilities to help the company avoid violations? How should you handle an office claim of harassment or discrimination? Claims of either discrimination or harassment can be reported by any staff member, whether the discrimination or harassment is against themselves or someone else. Discrimination and harassment claims can be directed to any call center supervisory or management staff or to corporate office staff, including the Vice President of Human Resources, Vice President of Operations, or the interviewing manager. As supervisors and managers, it is your duty to report any and all concerns that you encounter yourself or that may be brought to your attention. Harassment and discrimination situations can be perceived differently by each person. That is why it is important that all reports or claims are taken seriously. Do not be dismissive of any situation that you are approached with. These situations can create an uncomfortable, intimidating, or hostile work environment. It is your responsibility to prevent and address harassment and discrimination concerns to help the company maintain a positive working environment. If an incident has been reported to you, you must report the details, including the names of the individuals involved. This information should be reported to the call center manager and the designated corporate office staff unless any of those individuals were involved in the situation. All complaints will be fully investigated at the appropriate company level and corrective action taken if needed. No retaliations can be made against any employee who brings forth a complaint or participates in an investigation of discrimination or harassment in the workplace. Once you have been made aware of a discrimination or harassment complaint, it is part of your responsibility to enforce the no retaliation expectation and report any retaliation activities that you may observe or that may be brought to your attention. As with all employee matters, these investigations should be kept confidential, and the investigations will only involve the necessary parties to consider the claim. We previously covered how the Americans with Disabilities Act protected individuals with identified mental or physical disabilities from discrimination and harassment. In addition to that, the ADA further stipulates that an applicant or current employee with a physical or mental disability may request reasonable accommodation from the company in order to perform the job. We as a company are required to make any such accommodations so long as they do not impose an undue hardship on the operation of our business. Should you receive a request for accommodation, the written request should be immediately forwarded to the corporate office for review by either the Vice President of Human Resources or the Vice President of Operations. Failure to forward an ADA request for review to the corporate office could result in an ADA violation on behalf of the company, so all requests must be taken seriously. The Federal Family and Medical Leave Act. This law requires that eligible employees be allowed up to 12 weeks of unpaid job-protected leave for certain family and medical reasons. An employee is only eligible under this law if they have worked for us for at least 12 months and have worked at least 1,250 hours over the past 12 months. Historically, the company has honored this allowance even for employees who do not fall into the employment requirements noted in the law. Requests for leave of absence for family or medical reasons should be submitted to the call center manager for approval and documentation. Any additional questions about such leave should be directed to the Vice President of Human Resources. The Fair Labor Standards Act. There are a few provisions in the Fair Labor Standards Act that supervisors and managers need to be aware of. Overtime pay, child labor hours, and nursing mother requirements. Overtime pay. Aside from management staff, all call center employees are considered non-exempt employees. Should they work over 40 hours in a work week, the company is required to pay that overtime at 1 1/2 times the employee's regular rate. As such, it is critical that all employees accurately record their time worked on the time clock. As stated in the policy manual, any employee working overtime must have prior written authorization before working any overtime hours. Be sure that your staff is aware of this requirement to have overtime pre-approved. The company would need to pay employees for the overtime even if it was not approved. However, unauthorized overtime may be subject to disciplinary action. Child labor laws. Children under 14 would not be permitted to work in our call center per FLSA guidelines. Children age 14 or 15 are restricted from working more than 3 hours on a school day, and the latest they can work is 9 p.m. during the extended period of June 1st to Labor Day. The rest of the year, they cannot work after 7 p.m. Because our shifts are a minimum of 4 hours and go until 9:30 p.m. year-round, no supervisor or manager can hire anyone under the age of 16. Our applications ask if the applicant is 16 years of age or older. As with all information on the application, be certain that you are reviewing this question on their application form before offering anyone a position. Nursing mothers. The Patient Protection and Affordable Care Act amended the FLSA to provide a break time for nursing mothers to express milk. Within our company, nursing mothers would need to clock out for break time, as all staff are required to do for breaks. However, the duration and frequency of breaks of nursing mothers cannot be limited for their first year after having the baby. Additionally, we are required to provide a place other than a bathroom for employees to use when expressing milk. Note that the designated rooms in the call center are either the manager's office or the front training room. There are some additional employment laws related to wages, including the FLSA that we have been discussing and the Equal Pay Act. Due to our company's pay structure, we have eliminated the possibility of violations by supervisors or managers. Minimum wage laws within the FLSA are covered within our company. The FLSA requires $7.25 per hour as minimum wage. All of our staff starts at a base wage of $9 per hour. The Equal Pay Act requires employers to pay men and women equally for doing the same work, equal pay for equal work. As you know, our pay structure is set up so that supervisors and managers do not have influence into how much an employee can make. All employees start at the same base wage. Bonuses are paid based on employees meeting set guidelines for production and hours worked. Base wage increases are based only on the hours worked for the company. Because our pay system does not have any subjective human influence in pay determinations, this allows us to avoid any potential violations of the Equal Pay Act, as well as the previously discussed anti-discrimination laws. The National Labor Relations Act guarantees the right of workers to organize and outlines the legal framework for labor union and management relations. While our call center employees are not currently part of a union, you as supervisors and managers must be aware of your limitations within the NLRA. Should employees even consider forming or joining a union, you may not interfere with, restrain, or coerce employees with regard to them joining or organizing a labor organization. You may not control or interfere with the creation or administration of a labor organization. You may not discriminate against employees to discourage or encourage support for labor organization. And you may not refuse to bargain collectively with representatives of employees. Should you hear of staff talking about joining a labor organization, do not react irrationally. Do not take any retaliatory actions or make negative remarks regarding the situation. Stay neutral and follow standard procedures in your day-to-day activities. Notify the Vice President of Human Resources and the Vice President of Operations. They will handle any negotiations that may result. As stated in our policy manual, use of company resources, including but not limited to telephones, computers, and equipment, is strictly limited for use of conducting company business only. Labor organization is not part of conducting the company's business, so employees would not be allowed to use company resources. Any violations of the use of company resources policy should be handled per the set guidelines by the call center manager. Occupational Safety and Health Act, or OSHA, assures safe and healthful working conditions for working men and women by setting and enforcing standards and by providing training, outreach, education, and assistance. The nature of our business does not require us to keep OSHA injury and illness records. However, all businesses must report to OSHA any workplace incident that results in a fatality, inpatient hospitalization, amputation, or loss of an eye. To ensure that we are covered in these incidents, you are required to report all workplace injuries. A written report of any injury occurring in the workplace must be submitted to the Vice President of Human Resources or Vice President of Operations within 24 hours of the incident. In the event that the workplace injury results in a workers' compensation claim, the corporate office will already have information on the incident if supervisors and managers are properly following these reporting procedures. Thank you for your time. We have covered a lot of material today, and you will likely have questions as you encounter new situations. Feel free to review this training session as needed and consult the corporate office if you have questions. Never try to handle a situation that you don't have enough knowledge about. Again, thank you for your time. You can get further information by visiting any of these reference materials or contacting the corporate office.